This is a special edition of the Digital Dive Media Podcast, and we are talking with Rachel Neufeld, an associate at Morris, Manning & Martin. She's a part of the technology transactions practice, and also a subgroup of that, the data security, privacy, and breach group. And today we're talking about GDPR. If you are in marketing, you've probably heard it or seen it around. There are some pretty important deadlines coming up. And this is impacting our industry in a tremendous way. And what it is, how it affects you as a marketing professional and sales and any sort of, if you handle personal data at all, this is very important for you. So Rachel, if we could start maybe just first covering what is GDPR?
Sure. GDPR is the European Data Privacy Law, and it stands for the General Data Protection Regulation. It comes into effect on May 25th, so that's coming up pretty quick.
So you said European. So does this affect businesses in the U.S.?
It does. The GDPR is to date the most expansive data privacy regulation that has been enacted, and it actually impacts any company that has any European employees, any European customers, or even any company that markets to an EU citizen. So even if a company is based in the U.S. and doesn't have any employees in the EU and doesn't have any active customers in the EU, but they're still marketing, they're not blocking off Europe from their marketing efforts, then they still technically they fall under the GDPR.
Okay, that's a pretty important. I think that last point, if you're not blocking off your reach into the European market, this is important for you.
Yes.
What constitutes personal data?
Yes, and this is a good question to touch on, mostly because the definition is quite different than what it is in the U.S. In the U.S., there's personally identifying information and non-identifying information, and it kind of hinges on whether it's the name or email address, or whether it's something like an IP address or anything like that. In the U.S., you don't have to worry about any of that. But under GDPR, it includes all of that information. The standard is anything that can be used to identify a person, and that includes typical things like full name, home address, email address, but it also includes things like your login name, your screen name, social media handle, metadata. So, your search history, activity history, your Google search history, that's personal data, IP address, cookies, all of that is considered personal data under GDPR.
And what's this big deadline coming up at the end of May?
Sure. So the deadline is May 25th, and what that is after May 25th, the GDPR can be enforced against a company. So GDPR came out in 2016 with this 2-year safe time for companies to ramp up their efforts and get in compliance. So once May 25th hits, this can be enforced against a company.
Okay, that's coming up pretty fast. And in my space, I'm just now starting to even hear some of my marketing counterparts talking about it. And I feel like it should be a much more important conversation considering the penalties and the deadline. So how exactly is this going to affect the sales and marketing teams of an organization?
Sure, and GDPR, it doesn't specifically call out sales and marketing groups. So I think that's where some of the disconnect is, where companies don't realize that they have to comply with this. But really, it applies to any team and any company that's using, collecting, storing personal data. And that, very squarely is a sales or marketing team, because they are using someone's name, they're using their email, they're using their job title to try to market to them. So sales and marketing people definitely need to be aware of GDPR and what the requirements are for them.
And what is required of them to stay compliant?
Sure. So it's actually pretty simple for sales and marketing teams. There's essentially 5 steps that 5 questions they need to go through and ask themselves in order to make sure that they are compliant with GDPR. And these are, the first question is to be aware of where the personal information came from. And this would be something like, did a user go onto a website and put their information in to get marketing materials, specifically to get marketing materials? And you can contrast that with, there's third-party tools that will scrape web data off of LinkedIn and send that to a sales team, put that in Salesforce. So the first question is just to know where the personal information came from. The second question is to look at whether the individual data subject consented to being marketed to. The third question is, if yes, if they did, then the sales and marketing teams need to make sure they're documenting that they got consent and where they got consent and how they got consent. So if someone were ever to come back and say, oh, did you have consent here? You're able to show you have documented proof that you did. The next question is, if you don't have consent or you're not sure, what can the company still do with that information? There are things that you can still do, so that's good to know. And then the fifth step really is that you always need to make sure that you're providing a way to unsubscribe or opt out of future marketing. And if the data subject has opted out, you have to honor that opt-out request.
And so a big part of marketing and sales involves cold calling. Can you cold call under GDPR?
So lawyer answer is that it depends. So under the nature of cold calling is that you do not have prior consent to market to that person. So there is no consent. So you would jump up to the fourth step of the 5 steps and say, okay, you don't have consent, so what can you do? So fortunately, under the GDPR, they specifically called out marketing as a legitimate business interest of a company, which is good and it makes sense. Without marketing, a company can't sell its products. If they can't sell their products, they can't, they're not going to survive. So in order to use a legitimate business interest as a substitute for consent, you have to go through this balancing test that's laid out in the regulation. And essentially the test is whether your business interest overrides the data subject's rights, or whether the data subject's rights, their right to not be contacted, overrides your legitimate business interest. And the distinction here, so this is one of the areas that there has not been much guidance written yet about how this is going to be applied, how this balancing test is going to go out. Limited guidance that we have so far has it hinge on whether it's B2B marketing or B2C marketing, in that if you're marketing B2B, which is business to business, someone has a expectation of being contacted as part of their business role. So if a company is trying to sell its software to another company and they might contact the CTO, which is the Chief Technology Officer of a company, you're contacting them within their role and they have an expectation of that. So in that situation, the company doing the marketing would be okay under GDPR because their legitimate interest in marketing was not overridden by the person that they're contacting, their rights. And if you can contrast that with if you're marketing your software to a consumer who has not expressed any interest in your software, you have no reason to think that they might want your software, and you cold call them, that one's a little bit more iffy because that person has no expectation of being contacted by you.
What about previous databases? What about databases that you already have? Can you still market to them the same way?
So no, that's a really good question. No, you can't. And there's no grandfather clause for information that you've had. And a lot of our clients are sitting on databases of thousands of people that have used their product years ago, or they've gotten their leads somehow and they've just amassed this big database of marketing leads. They cannot use those leads after May 25th unless they can either one, show that when they got consent originally it was compliant with GDPR, or they actually go out and re-get consent from that data subject to market to them. So we have we have lots of clients who are doing a lot of very creative campaigns right now to try to get consent again from their big databases of subjects before May 25th.
What can an organization do to be proactive about being compliant? So beyond sales and marketing, it sounds like the entire organization needs to get involved and understand the seriousness of this and what they should be doing. What can they do?
Sure. So the very first step that should be done is what we call a data mapping exercise. And it's where a bunch of different, like the sales team, the product team, development, a bunch of heads from different teams will get together and they'll actually chart out data that flows through their organization. So they say, okay, where do we get data from? Where do we store it? Who can access that data? How long do we keep it? Do we share it with third parties? If so, to who? And by having that information, you'll be able to see, one, whether or not you actually do have data, EU citizen data in your systems. Some of our clients come to us and they've read, the 4% fine on global sales and they're freaking out. And then they come to us and we do this with them and they actually don't have any EU citizen data. They don't have any EU employees. They only market in Georgia and they're okay. They don't need to worry about it now. But the very first step needs to be, what data do I have, and kind of track it through its life cycle in your organization.
And then what would be the next step after they figure out, okay, we do have EU data? Are there services, or I'm assuming that people, first they need to consult legal, right?
That would be the next step. Some clients come to us and they've already done the data mapping. We don't need to be involved in that. We can obviously help you, and we have questionnaires that we can send out to clients to help guide them through that process. But then, yes, they would speak to a legal counsel, and we can help you decide what deliverables do you need, what documents do you need, what internal policies do you need to get set in place so that on May 25th, you'll be compliant.
Wow, this sounds like a really big deal. It makes me nervous, and I don't have any EU clients. I'm thinking, I guess, just on a larger scale, this sounds like a much bigger deal than I think people realize. The step one, first identifying if this is even applicable to you, I think is great. But I have a feeling it's probably applicable to more people than they think. And it sounds like the process is a lot more involved. Legal is going to be essential. We're going to drop your information. And also for the podcast, if you could give your email address, if somebody has a question specifically about GDPR and how to stay compliant, how can they get in touch with you?
Sure. And my email is rneufeld@mmmlaw.com. And I'll go ahead and spell that. It's RNEUFELD@mmmlaw.com.
This has been great, Rachel. Thank you so much for your time. I appreciate it. It's a lot of good information. I'm learning tons about it seemingly every day. And I know as we get closer to the May deadline, more people are I think there's going to be a scramble at the end, and people are going to be like, wait, we have to do what? And like you said, you guys have clients that are trying to put together campaigns. It was the first thing I thought about. I don't have any EU clients, but I have a list because I'm a marketer. And so I'm like, okay, so logically speaking, I need to launch some sort of campaign about consent and, do that whole thing. And just like you stated, you have clients that are having to do that. So thank you so much for your time. And we might want to touch back with you in a couple of months and see how this thing is panning out.
Sounds good. Thank you so much.